Hello and welcome to Supreme Court Observer's live daily update. I'm R. Sai Spandana. I'm an associate editor at SCO. Our main story today concerns a judgment pronounced by a 5-judge constitution bench of the Supreme Court yesterday. The bench was led by Justice S.K. Kaul, and Justice Sanjeev Khanna pronounced the judgment on a matter relating to the discretionary power of the Supreme Court under Article 142 to grant divorce on the basis of an irretrievable breakdown of the marriage. Yesterday, the main questions before the bench in this case were, firstly, what the scope and the ambit of the Supreme Court were under Article 142 to grant divorce. Number two, whether the time period prescribed by the Hindu Marriage Act for a divorce by mutual consent under Section 13B could be altered and set aside by the court, and if so, when that could be done. And thirdly, if the Supreme Court could use its powers under Article 142 to grant divorce on the basis of an irretrievable breakdown of marriage. Now, this ground is not one that is statutorily recognized in the laws of India. However, it is a very common ground for divorce in many countries and jurisdictions abroad. Now, first to speak about what Article 142 of the Constitution is. To put it briefly, this article grants the Supreme Court discretionary powers to adjudicate matters that are not specifically listed in other provisions of the Constitution. And yesterday, the bench pronounced the judgment in matters of divorce on the ground of irretrievable marriage that for these cases, the court did have powers under Article 142, Clause 1 of the Constitution to grant divorce, but this discretion had to be exercised with caution and could not be against general and specific principles of public policy. Justice Sanjay Khanna, while pronouncing the judgment, also clarified what general and specific principles of public policy were. He said general principles of public policy were essentially things like fundamental rights, principles of secularity, democracy, and other aspects that form the basic structure of the Constitution of India. And specific principles of public policy were those that were very specific to each particular legislation. In this case, for instance, it's the principles enshrined under the Hindu Marriage Act that is in question. And Justice Khanna stated that while exercising its power under Article 142, the Supreme Court could not contravene these principles and could not make a decision that is fundamentally against what the constitutional or statutory principles were for interpreting. Now, to come to the second question of whether the court had the power to set aside the time period prescribed under Section 13A of the Hindu Marriage Act. Section 13A of the Hindu Marriage Act grants couples the right to seek divorce by mutual consent, and the time period prescribed for this is a minimum of 6 months. And in this regard, the bench held that it could set aside this prescribed time period under Section 13A of the Hindu Marriage Act, again on the principles of, on a case-to-case basis and not contravening general and specific principles of public policy. Now, answering the third and last question of divorce on the ground of irretrievable breakdown of marriage. As mentioned before, this is not a ground that is statutorily recognized in the territorial laws of India. However, the bench did hold that it could allow couples to seek divorce on this ground, but it was subject to the discretion of the court on a case-to-case basis, and it was not a matter of right for the parties. That is to say that a married couple could not say they had the right to be granted divorce on this ground and approach the Supreme Court directly. Further, the Supreme Court also clarified that while this power existed under Article 142, this is not a power that could be exercised, or this is not a right that could be sought by any citizen under Article 32 of the Constitution. That is, a writ petition could not be filed for seeking divorce on the ground of irretrievable breakdown of marriage. Lastly, the court also clarified a few cases and factors that had to be taken into consideration before making the decision of whether there has been an irretrievable breakdown of the marriage. These factors included but are not limited to things such as when the last time the couple cohabited was, the nature of the allegations in the matter, and whether there were previous attempts made to settle this dispute in courts or in other modes of adjudication, such as mediation, the period that the couple has remained separated, etc. So, subject to these guidelines and considerations, the court finally did hold that it had the discretionary power under Article 142 to grant divorce to couples on the ground of irretrievable breakdown of marriage. Now, to very quickly speak about another case heard by Justices K.M. Joseph and B.V. Nagaratna today at the court. This concerned the early release of the 11 convicts in the Bilkis Bano gang rape case during the Gujarat riots in 2002. Last hearing, the respondents, the state had actually expressed their intent to file a review petition on the court's order asking for the government to produce certain documents. However, in this hearing, none of that came up before the court. A chaotic back and forth took place concerning the particulars of one of the convicted men in the case, and ultimately the case has been posted before the Supreme Court again after the summer vacation of the court. So at that point, another bench would have to be assigned because Justice K.M. Joseph will be retiring in the month of June. That concludes our live updates for today. We will be back tomorrow with live updates of the plea to marriage equality. Follow us on our social media pages. Stay tuned to our website for all the latest updates. And also follow our Twitter tomorrow for a live thread of the ongoing hearings before the Constitution Bench. Thank you.